Mahadeva. I'm a solicitor working principally in family and commercial law, and my background is I qualified with an LLB in '84 from the University of Adelaide. Since that time I've worked in Malaysia, Western Australia and Adelaide. Principal areas of practice, now it's family law and commercial, but I've had a wide-ranging experience including personal injury, work cover, criminal law, and documents transactional type law. Okay, I run a practice. It's called Legal Projects. It's an incorporated legal practice. At any one time, it probably has 2 to 3 permanent staff, including myself. But depending on the needs of a particular matter, or as I call it, a project, I bring in other people to add some bulk or to share the load more evenly. I also work with the client's team, if they have one, and the basic philosophy is to allocate resources in an efficient way and get the job done effectively with a lot of communication going all around. Firstly, being paper-based, that swallows a huge amount of time just in moving things around and reinventing the wheel. So that was a big part of it. The second element was clients are often capable of doing more basic tasks. So by including them, you get a double win. Firstly, they're more engaged in what is their matter after all. And secondly, by doing the basic tasks, they are not charged for it and free you and other people up for more high-level things. So you should, in theory, come up with a better result all round at same or lesser cost than if you try to do it all by yourself or within your firm as a practice. The caveat here is that they've got to have some ability with language and so on, but assuming that's the case, they can do things like organising documents in chronological order and making sure that an email, for example, has all its exhibits attached. They can do simple chronologies if they're shown how to do that and cross-link that to documents. They can do some basic internet research. They can do first drafts of statements, their statements in particular, and again cross-link this to the chronology and documents. So it's actually quite a bit they can do, but at the most basic level you can teach them to gather all relevant information, even if you have to sift and sort it to various degrees. Yeah, I suppose you have to let go, particularly if there are price imperatives these days and you're in a competitive environment. You really have to think very hard about how do I do more for the same price or charge less and get the same thing done. So those are constant pressures all the time. And particularly, I think, going forward, clients are much more savvy. They look on the internet. They're price conscious. Not that I think price is the only, be-all and end-all of it all. But I guess at the end of the day, the concept of value for money, it's something you've got to be aware of. You can have points of differentiation there, but at the base level, people need to know what they're getting and how much they're paying for it, like any other service they might buy or goods they might want to purchase. By and large, depending on their ability and inclination, I think they're very receptive to it. Usually with any matter, it's almost a given that they will come to me with documents all sorted in a particular order. I do give them, a sort of a training run on how to organise these documents because they have to be done in a particular way, and you don't completely accept the client's organisation as being totally up to speed. But, if the total time in managing the documents and getting them in order was 100 units, if you did it by yourself, clients can reduce that by 50, 60, 80 units. So there's a definite saving there. Yeah, I think it lends itself to giving fixed prices for perhaps the less complex legal matters. And the normal approach, I must say, when I was a younger practitioner, when asked, for example, litigation, how much will it cost, is to get the answer often, how long's a piece of string? Now, that sort of approach is very worrying for a client, and also, they don't really know what they're getting. So how could they make informed decisions? And if they can't make informed decisions, it unsettles them, it can upset them, and that can have an impact on their perception of your service. I mean, you might think you're doing a great job, and maybe you are on one measure, that measure being pure legal work. But my belief is clients don't come to you for necessarily how brilliant your legal work is, but more in how you can package something and get them a result that they want. So it's important to know what they want. Rarely is it, show me your brilliance in this aspect of property law or something like that. That they assume you can do. What they're more interested in knowing is how you can take them to where they want to go as cheaply and effectively as possible, and communicating with them the process all the time. So that's what I think, most clients these days want. My experience is that family law tends to work well in this area, provided the client is not too distraught and not still in that very emotional phase of a background. In the background, rather. So I think most people are very teachable, and family law, being very paper-based, tends to be well suited for it. Having said that, there's no reason why, say in commercial litigation, you can't do the same thing. The critical issue is to outline where you're going, have a roadmap if you like. Once the client can picture something, it's easy for them to work out where things slot in. I think of legal project management to be not unlike the process of buying a house, which you want to build. If you're a first timer, you want to go in and see what's possible. So you need some education about what the possibilities are for a house. In the same way, someone with a commercial problem or a marriage breakdown really wants to be educated on what the issues are. Once you've got that, you can narrow down the options and say, yes, I'll have that, and that's the direction I want to go. And then hopefully you get the process explained to you and ideally represented diagrammatically or in a pictorial form. And once the client understands that and has got a clear picture in their mind, then it becomes easier to communicate where in the process you are. I suppose there's, in my mind, two types of unpredictability: really big unpredictable events and lesser unpredictable events. If I take the lesser unpredictable events first, well, that's a risk that either you as the practitioner will bear or the client has to bear, particularly if you give a fixed fee or one with a small estimate. Well, someone will have to bear that. And it depends, like everything else, like insurance, for example, how the risk is allocated. So you might tightly scope things and say, anything outside of this you'll have to bear and at an hourly rate, and this is what it is. Or you can say, I'll take the whole process, say you're doing a plea in mitigation, a criminal matter, I'll do the whole process, and if it gets adjourned a couple of times, well, it's all part of the fee. Then you also have the big ticket items. For example, you're all prepared, you go up to a trial, and for no fault of yours or the client's, it gets adjourned. It might get adjourned because the judge can't make it, didn't get on a flight and arrive in time. It might get adjourned because a matter with a higher priority, which is expected to settle, gets bumped off. Now, with those things, you normally want to make that outside your scope, but you do want to warn your client that that's a possibility. It's a difficult thing. I mean, how exhaustive is the list of things that go wrong that you make? And you also have to be careful you don't drown the client with a sea of information. So there's a balancing act to be done. But I think the issue of managing a legal project, again, people do big things like building skyscrapers or bringing a new airline into operation. Now, in the scheme of things, those things are far more complex, I would say, than all but the most complex of litigation. So things there get done. The Royal Adelaide Hospital, for example, was a massive project. And while there were cost overruns and budget blowouts and so on and so forth, something did get delivered. Hopefully, the things that could go wrong were discussed and the issues considered beforehand as to who was to wear the cost overruns on those sorts of things. So if my thinking is, if you can do a big project like that and bring that into a reality using project management, then it should be possible for legal projects to be done the same way or similar way. Yes, that's right. Because to keep a staff of people going, you need to constantly, as it were, feed them. You've got to make sure there's a constant volume of work to bring in and so on. And there are firms for which that is a good way to operate. Being a smaller firm, probably 2 practitioners, sometimes 3, and not having a lot of support staff, we are lean, if you like, and we put on people or add more time to a project as and when the need arises. So I think project management suits having a small setup of staff, and depending on the project, you get in touch with other people who you've got relationships with to build up a project team. So other people are contractors, for example. You need to spend some time developing those relationships, but once you've got that, it's possible. It's not without its difficulties. Sometimes people move on. Then there's a gap there which you have to fill, and there's a certain amount of having to train people in how it works. But if you're comfortable with that, then, and depending on the sort of project you take on, usually you can make it work. I think they need training to do it. I think they're lucky in that they're junior and haven't yet formed habits, particularly habits that don't make them get into a project management frame of mind easily. But if they think about a project, for example, I think an assignment that they have to submit at law school, well, that's very much a project. You've got to get organised, you've got to know your timelines, you've got to know what the content is, and so on and so forth. So from that point of view, they've already got the training for it. As far as bringing that to legal work, they need some exposure about how legal work comes about. But once they do that, I think if they keep in mind, I want to get a solution for this client, here's the range of options, here's what I'm working with in terms of a budget and in terms of time, how do I make all this work in a coherent way? How can I bring the client in so that they're informed all the time? So if they think along those lines, eventually, and I suppose study some project management. I mean, that could be something that I think could be usefully taught at a law school as a, not as a mainstream subject perhaps, but as an optional subject. If that's done, I think it could make a real impact on them being out there in the workforce, particularly for those who want to set up their own firm after a short time of supervision. I think project management is probably a very useful way to think about it. Well, I'm an older lawyer, so I certainly grew up in the time of manual typewriters and files simply meaning paper around which you put up protective situations. You'd have seen pictures of trolleys being wheeled into various courts. Well, that was all very much part of what I grew up with. I suppose one is going back to the belief that only paper is the only way to work. You really got to get into the frame of mind that electronic documents are far, far more efficient. Some courtrooms, as I understand it, are set up so that every lawyer, there might be a whole stream of lawyers there, and everyone who needs to look at the document at the same time has a viewing screen, and the same document is put up at the same time. Now, if you compare that to the old way of doing it, which would be to have a document, refer to that in the book of documents if there is one, make sure that the right document is pulled up and submitted. Often there are errors because no matter how well they try and duplicate things, something's left out or so on and so forth. And it can take, my estimation, 3 or 4 times as long to get everybody on the same page, literally, and to understand what you're looking at. Whereas if you had it on screen, there are methods for identifying the passages that you're talking about, and everybody's seeing exactly what you're talking about, as opposed to saying to somebody, if I can direct your attention to the 5th line on this page, see the words blah, 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 what do you say about that? Whereas you can just say, this on screen, what's highlighted in yellow, ask for your comment about that. So it's a massive, massive difference. So I think old school lawyers maybe need to get out of that a lot more. As you say, lawyers want a lot of control over what they do. And often with good reason. If you're responsible for the product that turns up in court, it's not going to be much of an excuse to say, oh, well, my client did that part of it. So that won't fly. So you've got to build a measure of quality control, or quality assurance into what you do. So I suppose the concept is not a concept I came up with, but I think it's Gorbachev in the context of nuclear weapons, and that's trust but verify. So you trust the client to do certain things, but you've got to put in methodology to verify what they're doing is what you wanted. And I've had particularly good examples of that coming from clients. So you can have work that's incredibly good, or you can have work that you need to work on top of the work put in by the client. I would suggest to them that they get some matters under their belt which they can speak about, to potential employers. So if they say, I spent, last couple of summers working at law firm XYZ, and what I focused on doing there was applying project management concepts, and I did that so that the whole lot of work that I had to do was much more efficient and effective, and I measured that by making sure everybody was in the loop, not getting communication or feedback that things are missing, clearly articulating back to my boss or whoever was instructing me as to what they wanted, even if they were vague about it, and just making sure I was able to deliver what I was expected to deliver, but not taking for granted what it is I was expected to do. In other words, I took responsibility for moving the whole thing along, even if I was working in a subordinate position. I would perhaps start by saying, give me an example of a big project that you've been involved in and how you were involved and what you did and how you managed to play your role effectively. So I'd ask him something like, it needn't be a legal project that they undertook. It might be something else. It might be even organising a function, organising a trip overseas for a number of law students or a moot. So really I'm looking for an organisational brain, someone who takes the initiative, someone who chases down resources if they need to, rather than get stuck with a particular problem. Almost all problems, I think, have a solution, maybe not a solution that you like or want, but the ability to research and brainstorm options, that's important. Also attitude's important, how they see clients. They see clients as adversaries who, have to be placated, or do they see them as people who, when included in a team, can actually, do a lot? Not the least of which, when they share the problem, they're less harsh on you when the problem doesn't go as well as you might want it to go. So I'd look to their people skills as well, how they work in a team. A lot of this sounds very cliched as I say it, but it's becoming increasingly important. I think the thing I've seen as I've spent over 30-something years in the law, is how increasingly demanding it all is. There are lots of different pressures that get applied on you, and you've got to respond well. The issue of mental health for young practitioners and practitioners generally is, getting a lot of airplay, but it's always been so. It's always been a very demanding profession, and anything you can do to give yourself a break and an edge, it's a good thing. So even on an informal level, if they've read about legal project management, they have some concepts. At its simplest, it's really the triangle of cost, scope, and time. That's really what it's about. And if you can translate that into their own legal work or anything that they're doing as a project, then they're a long way to getting the skills for getting legal work done. They need to be able to say how they've contributed towards achieving a project milestone, or how they formulated the scope of something and communicated how to get there. So if they've done that in a team environment, that's good, but it does require a degree of leadership. You do have to show initiative and take control rather than have the project happen to you. You want to make the project happen. I think that's really important and becoming increasingly important. If you can do that, I think you'll be in demand anyway. The time of a supervising lawyer is, both precious and expensive. I'm sure they would rather be doing client work, and increasingly, and perhaps unfortunately, young lawyers are not getting a lot of supervision time. I grew up in a time where things went on at a more ambling pace, and senior practitioners were prepared to spend more time editing your documents and so on and so forth. I'm sure that still happens, but the window for getting that sort of support is contracting. And the more you can make that, help yourself get the necessary skills through being more efficient somewhere else, the better I think it is for you. Yeah, I think sort of giving law students some real life experience beyond just, I think, giving them, when I had my time at law school, you'd spend 2 weeks in your final year, I think 3 times 2 weeks in a law firm or as a judge's associate or something like that. I think all those things are important as well. But if you can have a legal clinic, for example, running matters for people and really focus on real life matters and bring in some project management skills to that as well, so that people are working within the parameters of a project, I think that would be a very useful skill, rather than just one of you turn up and, okay, I told get the client's instructions. Well, it's very hard for a law student to understand what that really means, besides getting the client's story. So if you can show them a process and say, what you're trying to do here is understand what this person really wants, not just what might be solutions legally to their problem, but what is the all-out solution to their problem. And then you need to think about what resources you have to bring to bear to achieve the problem. Achieve the solution to the problem. You've got to communicate to the client and get their buy-in to the solution to the problem, and track this as a project and see how well you're doing. Bring in some diagrams. I think as lawyers we're just too much into the words. Words are good, but pictures are better. If you can represent information diagrammatically or pictorially, in addition to doing it by words, I think you achieve a lot, and in my view that's the way it's all going anyway. So use the words where they count and where it's really important, where it's an interpretation issue, but where it's a communication issue, as in a process, process maps, charts, so on and so forth, I think do a world of good. I think the practice of law, if you want to practice as a lawyer, is more and more challenging. And I'd advise students, I suppose, going out to try and form the best possible habits so as to get their work done in a timely way and in an effective way, while preserving for themselves and for their family lives some time outside the law. I think just doing law and nothing else is a recipe for insanity, and it's a very unhealthy way to be involved in the law. Unfortunately, you've got to manage that process very actively, because if you don't, it's quite easy to get swallowed up by law and the legal process. So I'd ask students, for the sake of their mental well-being and being effective, to try and separate and compartmentalize the law with the non-law aspects. Now, I might be accused of giving advice that I haven't followed myself, particularly in past years, but increasingly I'm trying to wrest the ground I've lost, and just trying to get on top of it. This is part of why I came up with the idea of, well, I didn't come up with the idea, but why I was attracted to the idea of legal project management. So that's probably my suggestion to students.